our friend David Rivkin, a partner at Baker Hostetler. He served in the Justice Department under Presidents Reagan and George Herbert Walker Bush. David, good morning.
Good to be with you.
Thank you. What did the court decide, and is this the end of voting rights?
Of course not. The court has decided that the one particular section of the 65 Voting Rights Act, namely Section 4, that contained the criteria that caused a number of states to be subjected to the federal oversight, the so-called preclearance, was no longer constitutional. And what's important to underscore, again, how modest is this result. There are a lot of other provisions in the Voting Rights Act that are undisturbed, including Section 2, that allows challenges to any discriminatory decisions. The Section 4 really treated a number of southern states differently from the rest of the country, was an extraordinary remedy whose constitutionality has always been in doubt, even when it was upheld in 66. But, Bill, the only reason, and the court said that in 66, okay, not only this week, the reason it was permissible was a very temporary measure to deal with very bad conditions, frankly, that existed in the South in 1965, were massive efforts to prevent blacks from participating in the political process. These conditions are no longer present.
What was the unconstitutional part, or what provision? Is this 14th Amendment, equal protection laws?
That plus a fundamental principle that you cannot treat one set of states differently from another. So it's very much a federalism driven decision, as well, of course, the principle of individual equality. Because, again, this is not something that Congress, it's difficult enough for the federal government to intervene in the voting process, which is the prerogative of the states. But if you do it in a way that discriminates against a set of states, there have to be enormously compelling reasons to do that. Okay. And just to remind your viewers, what Congress has done in reauthorizing the statute, they continued to look at the old data. And Roberts, who wrote the opinion, quite correctly pointed out that if you look at all the key indicia of political participation, voter registration, voter turnout, if you look at the numbers for black and white voters in the South, the numbers are almost exactly the same. In some states, black participation is actually higher than white participation. And this is a number that grabbed me very palpably from the oral argument and the briefing period. Massachusetts has worse black participation, voter participation in absolute numbers than any one of the covered states. So this was clearly an exertion of congressional power, as the Chief Justice said, that no longer could be justified by any rational means.
Okay, we're talking to David Rivkin. If you have a question, 866-680-6464, 866-680-6464. And I should have said, too, Paul Ryan will be coming up at the bottom of this hour. What explains this rage in your view? And I guess quite apart from the rage, this is a 5-4 decision. We had 4, smart people, liberal justices saying absolutely not.
Well, 2 reasons as far as that rage is concerned. One is somewhat more philosophical, and one is more crass. The crass one is that while I would argue, and many others have argued, that this approach actually has not helped the Democrat Party, it has helped a generation of black politicians in the South because it basically led to gerrymandered districts, black majority districts that gave them an opportunity to be elected in the same fashion. Because any effort to change the drawing of electoral map was certain to be shut down by the Justice Department. The irony here, Bill, is that it was probably worse for the Democrat Party as a whole. But so you have politicians who, frankly, are concerned about their political fortunes. It's okay. I mean, that's what politicians do. The broader problem on the part of the media and the professoriate is it strikes at the heart of this narrative that I think is absolutely untrue, that we are still deeply a racist society, one step away from discriminating against people on the basis of race, and you need to continue extraordinary measures by the government at all levels to prevent this from arising. So in that respect, this decision doesn't just strike at or doesn't just strike down one section of the Voting Rights Act. It is the strongest challenge to this narrative, which, frankly, look, we have the first black president in our history being elected a second term with an unprecedented number of black senators and congressmen at state and federal levels. The notion that we are a deeply polarized racist society is absurd. It's crazy.
Yeah, fair enough to say, though, that it's changed. I mean, it has changed. But it's changed remarkably in 50 years.
58 years. And again, the irony is, and this is the same problem with affirmative action and some other manifestations of the same narrative or same paradigm, is people don't want to realize that things have worked.
Yeah,
We've won.
They have.
We are no longer
Yes.
the same society we were in 1965.
No, it's very well put. I told John Fund earlier in the show, I'll repeat it to you, and audience that's just joining us. Best example I found of this was in my own family, talking to my boys who were then preteen and teen, who said to me with a group of their friends, did people really hold it against people in the past because they were different color? I mean, they were incredulous. They could not believe that people actually discriminated on the basis of race. That's how much we have progressed.
Right, and what you just brought up is again a very palpable manifestation, and in many respects, at the personal level, the fact that racism just basically is not only wrong in the minds of most Americans, it's bizarre. To me is just as palpable as the aggregate numbers in terms of how many minorities we have exercising different levels of power in both private sector and public sector. And yet we have people who are just clinging to this narrative, as I said, as if we were just one step away from a resurgence of Jim Crow.
Yeah, let's play Al Sharpton real quick. I want to get David's reaction here.
What they've just done is really revoked a lot of what Dr. King's dream was all about. We built a monument to Dr. King, and part of at least half of what Dr. King's dream was about was voter rights, 65. They've just revoked that. They've just canceled the dream, and the children of the dream are not going to sit by and allow that to happen.
Now, specifically, quite apart from the outrage, David, specifically, won't there be an effort to put this back in through legislation? And it worked in, what's the year, 06 or 08? I can't remember when Congress voted by very large numbers for this.
Almost overwhelmingly.
And won't they try to embarrass people in doing it so that if they don't, they're voting against voting rights?
Yes, but I don't know if they're going to succeed. Of course, Republicans would be pushed very hard on this. One thing I wanted to underscore is if you look at the decision, I would find it very difficult to imagine how they're going to write it up. Again, you look at, you cannot, what the court said to Congress is, come back, look at it. If you come up with real evidence of continuing massive problems, then, come up with another gateway into Section 5, which actually technically Section 5 is what preclearance does. Section 4 was just the list of the states that were covered. And look, if you look at the key aggregate indicia, one is voter turnout and voter registration. There are just no disparities. There are no statistically meaningful disparities. So what is Congress going to come up with? Some anecdotal evidence, a la Sharpton, that somebody did not make it to the voting booth because it was not open, 2 hours longer than it would be impossible, in my opinion, to draft something that would pass.
I see.
The muster here. But
that
it doesn't
would pass
mean
or that wouldn't be struck down again?
Would be struck down again, provided the composition of the Supreme Court doesn't change. But, Congress is perfectly capable of enacting an unconstitutional law. They've done it before. I can think about many instances where the Supreme Court clearly said don't do something, and Congress came back and did it again. But what I would say for Republicans here and Democrats who do not want to go down that path, their best excuse would be, or not excuse, best explanation, Bill, is we cannot do it in a constitutional fashion. The other side, you tell us how you would write it. So it would have to be a debate about technical issues and not the merits from a policy perspective.
I got it. David, I'll tell you what we're going to do. We're going to leave it there because we're going to actually split your reservation and ask you if you're willing, if we get a big decision today in gay marriage, to come back tomorrow.
Would be happy to, and I think we're going to have two big decisions.
Okay. Thanks, David Rivkin. We'll look for you tomorrow. David Rivkin, ladies and gentlemen, we'll be back.